Based on the final draft of the charge that the court provided us, I guess yesterday morning, the court is going to charge that a private citizen's warrantless arrest must occur immediately after the perpetration of the offense, or in the case of felonies, during escape. If the observer fails to make the arrest immediately after the commission of offense or during escape in the case of felonies, his power to do so is extinguished. That's not what the state's arguing. They're arguing and it's a clear misstatement. The court should simply instruct the state not to argue an incorrect statement of law rather than putting the burden back on the jury to understand what the state's saying, what we're saying, and now what the charge is saying. The court has the power to do so and should do so.
In further support of the motion for mistrial on behalf of Greg McMichael, obviously this is the last word by any counsel in the case, and to argue the state's case, which we're perfectly fine with they're doing, is to argue the facts and evidence as the law applies to them, but not as a misstatement of the law applies to them that we can't correct except by making an objection when the incorrect law is being given to the jury by the state. So there's no way we can fix it. We're asking the court to fix it, not by simply saying to the jury that the law is going to come from the court, which it will, but that this is a misstatement of the law and this argument is improper.
Join.
Mistake.
Thank you, Your Honor. Yesterday, the defense got up here and argued their interpretation of the law. And I didn't object at all because I knew it was their interpretation of what they believe the law to be. They went through the whole probable cause thing. They called him a burglar. They went through everything. The state didn't object because I understood that this was their position of the laws applied to the facts. I've just made it clear to this jury, and I will again, that this is what the law is, and this is how you apply it to these facts, and this is the state's interpretation of how you read this law, just like they gave their interpretation in their closings yesterday. So we ask that you deny the mistrial.
Onward. Well, no.
Yeah. You can argue the law. You can't argue a misstatement of the law. The state never told the jury, this is my interpretation of law, until we objected.
Well, I think that's what was explained in the parenthetical, but the state does need, state needs to clarify that this is the argument based on the law that will be charged and with the law that will be charged, and make sure that we're clear about what the law is that's being charged. There was a debate about this on Friday, and I'm not going to reignite that debate in front of the panel.
We're fine with what the court's decision was on the contemporaneousness of the events. The charge is great. It's the state's argument about what that means that's flawed, and it's fatally flawed.
Well, the state has the right to, just like the defense had the right to argue that what escape means is escaping whatever this temporal period is. I understand the state to be arguing the same thing in a much more limited temporal period. I think the state's got the right to do that. The state needs to be sure, though, that it's clear that that is the argument that is being made as opposed to what the law is. And I think the charge is very clear about that. So the motion for mistrial is denied.
If I may add, the state is arguing that the felony for the second sentence has to have just occurred in the immediate presence of the person seeking to arrest the escaping felon. That is absolutely a misstatement of the law. Even as the court agreed to charge it, that's not even correct. The second sentence does not require the felony to have occurred within the immediate presence contemporaneous with the escape and the chase. That is not the law. That's not the law the court agreed to charge.
Your Honor, you're charging the statute. And the statute are those two sentences. The state's interpretation of that statute is if the offense, well, that is, the offense has to be committed in your presence or immediate knowledge. If that offense is a felony. I mean, that's what it says. If that offense, well, it's referring back to that first sentence. And the state's interpretation is, then that means that felony had to be committed in your presence. The person had to be escaping right then and there. And that's the state's argument to them, that they never saw anyone escaping from a felony that had been committed that day.
that's not what was in. So the escape, the second sentence the court was charging, which I understood was agreed to, was that if it's a felony and there was an escape, that's the temporal issue that we're talking about. Then those steps can be taken to detain or arrest the individual. What I understood the defense was arguing is that this temporal period stretched over some time. And what I understood the state was arguing was no, that temporal period is limited to what had occurred there, the escape. The word escape was he was escaping from whatever may have occurred that day.
Yes, that is what we're arguing.
Okay, well, that's not what I'm hearing then, because what I'm hearing is, well, if the state limits its argument to that's what the second sentence refers to, an escape, that limited temporal period, then that's permitted. That's what we talked about in the charge conference.
Yes, Judge.
I don't think that is what we argued about by email and all the rest, Your Honor.
Well, that's what I remember. That's what I'm saying.
The state will limit its argument to that.
Your Honor, if it's okay for me to step out just for a second, I will not disturb the jury if they're back by the time I get back.
I could also use a bathroom break. I assume that's what Mr. Hogue is looking for.
Okay. Let's just take literally 5 minutes, and then we'll get back into this.
Thank you, Judge.